Morning, everybody. I'm Jamil Jaffer. I'm the director of the Knight Institute, and I'm excited to be able to welcome you to this symposium on the free speech rights of public employees. In a sense, the Knight Institute is very familiar with this topic. We've defended the rights of national security whistleblowers, and we've called for the reform of the pre-publication review system, which imposes a system of prior restraints on millions of former employees of the intelligence agencies. We sued the CDC, the Centers for Disease Control, to learn about the constraints that the Trump administration imposed on the speech rights of government scientists during the pandemic. And we're still doing a lot of that kind of work today because the free speech rights of government employees turn out to be deeply contested in a lot of different contexts. We're currently litigating a challenge to regulations that restrict immigration judges from speaking publicly in their private capacities. We're also representing public university professors whose research about the social media platforms has made them targets of congressional investigations. And last year, we represented public university professors in a challenge to Texas's TikTok ban, asserting, as it turned out unsuccessfully, that the ban unconstitutionally burdened their right to study the platform. So those of us at the Knight Institute have some familiarity with the topic we're addressing today. But I have to confess that it wasn't until I read the concept note from Professor Lebovic that I began to fully appreciate the deeper connections between all of those cases, and that I started to understand the significance to our democracy of the questions that are presented by them. There are 22 million public employees in the United States. How we manage their free speech rights has implications for everything from the integrity of science to the legitimacy of national security policy. Of course, the question of how we, or how the government, should manage the speech rights of CIA agents requires a different analysis than the question of how it should manage the speech rights of, say, scientists for the CDC. But as Professor Lebovic proposes, it's illuminating and productive to consider how and why the trade-offs that we make between competing values in one context should be different from the trade-offs we make in another. Those trade-offs end up shaping public discourse and shaping our democracy. I want to say what a pleasure it's been to work with Professor Lebovic on this project. As I've already suggested, our collaboration with him has given us a new way of understanding the work we've been doing in the courts. It's also given us an opportunity to work with and learn from a whole set of scholars whose work we've long admired. So thank you to Sam for giving us that opportunity. Before I turn this over to others, I want to thank a few more people as well. A whole slew of people at the Knight Institute worked very hard to put this event together. I want to thank in particular Katie Glenn Bass, our research director, who oversaw the whole project with Sam, as she has overseen all of our other research projects. Lorraine Kenny, our communications director, as well as Isabel Adler, Kitty Ahmed, Mia Spire, Rashawn Thompson, Adriana Lamarande, and Kushal Dev. And finally, I want to thank all of the scholars and advocates who are contributing to today's symposium. It's really an honor for us to be hosting you here at Columbia. And I know that today's discussions are going to be enlightening and generative. And with that, I will turn it over to Ramya and the first panel.
Good morning, everyone. My name is Ramya Krishnan. I'm a senior staff attorney at the Knight Institute, and welcome to this panel on duty and dissent, public employee speech rights, and their limits. With me today are Daniel Walters, Associate Professor of Law at the Texas A&M University School of Law, Frank LoMonte, Legal Counsel at CNN and Adjunct Professor at the University of Georgia School of Law, Teague Paterson, General Counsel of the American Federation of State, County, and Municipal Employees, AFL-CIO, a national labor union of 1.4 million public service workers, and finally, Kate Andrias, the Patricia D. and R. Paul Yetta Professor of Law and co-director of the Columbia Labor Lab and the Columbia Law School Center of Constitutional Governance. On this panel, we're going to be discussing political conflict within the public sector. What are the democratic benefits of allowing public employees to speak freely? What are the democratic costs? And does current First Amendment doctrine strike the right balance between civil liberties and effective governance? So before we dive in, I just want to note that we have a QR code up behind us. I think it should be showing for those tuning in virtually as well. If you'd like to submit a question for one or all of the panelists, please use that QR code to submit your questions, and I'll try my best to get through them in this panel. So Daniel, I'd like to start with you. And in particular, you're writing about democratic agonism because I think it turns on its head one of the arguments we often see the government make in this context. The government argues that allowing public employees to dissent from policy decisions is going to harm public confidence in government institutions and also disable effective governance. But you argue that amplifying conflict in the administrative state may actually increase the administrative state's democratic legitimacy. And I'm wondering if you could explain how that works.
Yeah, sure. So first of all, thank you so much for having me here. And this is a wonderful conversation. I'm really looking forward to all of the panels today. But back up for a second. I'm really not a First Amendment scholar. I'm more of an administrative law scholar. And I wrote my administrative agon piece to respond to what I perceive as trends of extreme anxiety about the future of professional government, much of which boils down to beliefs that professional government, the civil service, et cetera, is in tension with democracy because we really don't vote for any of these people who are making all kinds of decisions that affect our day-to-day lives. And I argued that this concern reflects a failure to really fully reckon with what we mean by democracy. So allow me to lay a little bit of context here. Much thinking about democracy tries to force a square peg through a round hole. We need the demos, or the people, to control kratos, the power of government. And to do that, we need to entertain the fiction that there really is this demos, that this unified, defined thing. And we need to do this most often by running elections that settle conflict, at least for a time. Occasionally, civic Republican theorists and deliberative democracy theorists argue that we could and should augment elections with deliberative processes that generate consensus among the demos and reduce the scope of conflict. And in my piece, I highlighted certain contemporary political theorists who take issue with all of this and have complicated the fixation on reducing democracy to the practice of conflict settlement. Agonistic democratic theorists like Chantal Mouffe contend that democracy properly construed is really all about conflict maintenance or conflict generation. The goal isn't to settle conflict, but to continually unsettle a false consensus that arrives whenever we try to reduce the demos to some unified body of people. So in reality, the demos is kind of a mirage. It doesn't really exist. And in a diverse democracy, we have all kinds of conflicts that can't be settled without excluding certain people. Leaving a remainder is in the language that agonists use. And when those who are excluded see government acting on a false consensus, agonists would contend, they are understandably likely to lose trust in government institutions that don't seem to represent them as much as they represent the winners in elections and the like. And I contend in the piece that reorienting discussion about administrative law and the administrative state from a fixation on squaring professional government with elections and political accountability to a project of reinforcing contestation and unsettlement in the administrative process would be a better way to ensure that it's governed by democratic principles and capable of earning the trust of even those who are temporarily and necessarily disadvantaged by any concrete agency decision. So how does all of this relate to civil servant speech? I kind of bracketed the question in my article and just relegated it to a footnote, but it's an obvious extension of agonistic democratic theory to say that some civil servant counter speech is an essential part of democratic practice. Presidents and political appointees invoke the more conventional understandings of democratic accountability to justify mass suppression of civil servant counterspeech. There are, for instance, institutionalized and increasingly censorious controls on civil servant speech, both when it's openly resistant to political appointee or elected leaders' perspectives, or when it's merely not sensitive to the specific way that elected leaders and political actors want to use the bureaucracy to speak to the electorate and advance their agenda. So civil servants, we know, have to get pre-clearance to speak to the press or to the public in any way, including in increasingly important channels of communication like social media. And obviously we'll talk about it later in the day, but there's also serious risk in working around these restrictions. Leaks and whistleblowing certainly open up civil servants to risks of prosecution and harassment. And on the conventional view, all of this is justified because presidents are elected and they are ultimately supposedly advancing the agenda of the demos that settled things in the election. But if we come at these kinds of questions from an agonistic democratic perspective, this counterspeech is actually really valuable because it has the potential to give voice to those who are left out of the electoral settlement and to force presidents and their political appointees to grapple with the interests that they would prefer to ignore. So kind of a model for agonistic contestation, as I see it, is the State Department's Dissent channel, which has gotten a lot of press recently in the kind of disputes within the Biden administration over the Israel-Gaza issues. So the Dissent channel is a way for ordinary civil servants in the State Department to log their disagreement with the administration, with political appointees, and it's entirely protected and actually encouraged. So I think that gives a lot of positive press to civil servants who are doing their job and resisting policies that they disagree with. Now, of course, at the end of the day, people are going to disagree about those really tough issues, but the fact that that debate is actually happening in public and it's being reported on, I think, is a thing that lends legitimacy to the process. So I think that's kind of the model of agonistic counterspeech. Now, institutionalizing that across the board in the government is a tough thing, and I'm sure we'll talk more about that, but I think that that has the potential to reach people in the electorate who feel like they aren't being represented by the administration.
So Frank, you touch on the value of counter-speech in your piece as well. You write about the proliferation of one board, one voice policies that forbid members of elected or appointed governing bodies from publicly criticizing the body's positions once they've officially been voted on. You argue that these policies aren't just clearly unconstitutional, they're bad policy. And so I'm wondering if you could unpack that for us and explain what the sort of, why shouldn't agencies and other government employees be in the business of sort of manufacturing sort of appearance of false consensus?
Okay, thank you. So first, let me start with a disclaimer that I am here on a vacation day, not speaking for my employer. I should always start with that. I have my academic researcher hat on today, which I was in a previous life. And also thank you to the Knight Institute for focusing on what I would call the supply side of information. People like me who identify as media lawyers focus their work almost exclusively on the demand side, right? The rights of journalists to get into places, the rights of journalists to get information. And we focus much less on the rights of the people that we talk to, even though those are the people who are really in the greater peril, right? That's one reason why I don't particularly like the term reporter's privilege, and I prefer the term whistleblower protection, which is the term that the state of Wisconsin uses for their reporter's privilege law, because it is actually the source and not the journalist who is at risk of losing their job if they're exposed, right? And so I think it's important to focus on the supply side of information, the free flow of information, because without that, the work of journalists is nothing, right? And so thank you very much for doing that. I'm going to start with if you grew up reading comic books like I did, every comic book hero or villain has an origin story. And I will tell you my, and you can decide whether this is heroic or villainous, origin story of becoming interested in this idea. Go back a dozen years. There was a forum at the National Press Club organized by the Society of Professional Journalists. And one of the speakers there was the head of public affairs for the USDA, the Department of Agriculture. And he was explaining how he does his job as a practitioner of public relations in the government sector. And he said, when a journalist reaches out and wants to interview an assistant secretary or a deputy secretary at the Agriculture Department, before I will let them talk, I will sit down with that person and I will coach them and I will make certain that they have talking points prepared so that the message that they convey indicates that they are in perfect alignment with the priorities of the Secretary of Agriculture. And this is a very candid description of how government public relations practitioners do their jobs, but it didn't acknowledge at all that there might be a countervailing interest in the public actually knowing if the Deputy Secretary of Agriculture was not in perfect alignment with the Secretary of Agriculture and was pursuing different priorities, right? And so many of the policies that are in place, like these one board policies, prioritize and value this illusion of consensus, this illusion of unanimity over the ability of the public to have transparency and visibility into the way decisions are actually being made, which is both bad policy and, I argue, bad constitutional law as well. So let's start with you explained it briefly, but just to elaborate a little bit, right? What are we talking about? We're talking about like a one-board policy. We're talking about is a rule, a policy that applies to members of elected bodies, a school board, a college trustee board, a city council, county commission, that says that everybody on the board is bound to agree with the decision of the board and may only speak in favor of it after it has been rendered, right? And some of them even go further and say no one here is allowed to talk to the news media except for the chair of the board, and that if you as a school board member are contacted by the news media, you're duty bound to say only, please call the chair of the board. And of course, right, this makes it impossible for journalists or even concerned citizens to get a full picture of the range of differing opinions among their elected officials, right? And the justification of this is always the idea that, well, we should speak with one voice. That's why they're called one voice or one board policies. We should be consistent in our messaging to the public. And I would argue that in the hierarchy of constitutional values, conveying a consistent message or image to the public is of enormously low value, perhaps zero value, perhaps negative value. If there is one thing that the First Amendment is meant to do, it is meant to help to facilitate harming the reputation of the government, right? It is meant to help us put the government in a negative light. And if you don't understand that, you miss the first day of con law, right? And so if any policy that operates to forbid the discussion, right? Think about, so you learn there's sort of 4 pillars of First Amendment law that you learn your first week of con law, right? Pillar number 1. Prior restraints are regarded as almost categorically unconstitutional, something that stops you from speaking in advance. Viewpoint discriminatory regulations are regarded as almost always unconstitutional, right? Restraints on political speech about matters of social political concern, almost always unconstitutional. And restraints on the public's right to receive information as well as the speaker's right to deliver it are viewed with great skepticism. So then think about one of these one-board policies in that light. If those are the third rails of the First Amendment, a one-board policy touches each one of those third rails, right? It is almost impossible to conceive of a policy that is more constitutionally infirm than a policy that says elected government officials may not voice disagreement with official government policies, but are free to voice agreement with them. Only the winning side and not the losing side in a political controversy is free to speak publicly about it, right? And I can unpack the case law a little bit more when we get into the discussion, but just to go back to the headwaters of this, right? So in 1995, the Supreme Court decides a case called the Treasury Employees case. And this is a case that it's not even a categorical restraint on speaking. It's just a regulation that discourages speech. It's a regulation that makes it less attractive to speak. It's a regulation that says federal employees may not take honorarium in exchange for speaking, and it's a very nobly motivated law. It's meant to prevent influence peddling, regulators taking money in the guise of a speaking fee, right? But the Supreme Court readily strikes this down. It says overbroad remedy for the ill. There are many, many government employees who would speak and take the money and not in any way be influenced by it or not in a position to influence policy, and all those people are restrained as well. Overbroad prior restraint, unconstitutional. And following the Treasury employees case, court after court, including, importantly, here in the Second Circuit, which is one of the leading cases called the Harmon case. And the Harmon case in 1998 involved the local child welfare agency in New York City, and a whistleblower furnished some information to ABC News about a string of child deaths that had been covered up by the city child welfare agency. And when you think about, well, what things that are important for the public to know about the government's business, covering up deaths of children seems quite high indeed on the priority list of things that the public is interested in knowing. This whistleblower was found out and was punished, challenged the no talking to the media policy that was on the books at the Child Welfare Agency, and had it struck down by the Second Circuit, which said that a policy that prohibits furnishing information to the news media or that requires advance permission before doing so is a facially unconstitutional policy. And regrettably, there is an enormous disconnect between what the courts have said and the practice on the ground. I would venture to say that you could scratch underneath the surface of municipal agencies across the city of New York today and continue to find policies of this kind that are still on the books, regardless of the fact that they are facially unconstitutional. And so one reason why I wanted to write the paper, and I'm so delighted to be here today, was to just sort of call attention to this under-the-radar body of case law that tells us that the practice of government agencies, the widespread practice of government agencies, is misaligned with the First Amendment. And again, we get into Q&A, we can talk a little bit more about kind of the policy reasons, but those are the legal reasons why these one board policies, I think, are just dead men walking. They are just waiting for somebody to file the First Amendment lawsuit.
So the categorical suppression of speech about public employment seems obviously unjustifiable and blatantly unconstitutional, as you say, and that's an argument that we've made in a case representing the Immigration Judges Union and their challenge to a gag order on them about the work that they do. But I'm wondering if you think that there are certain sectors where the appearance of objectivity or consensus may be more important in a way that factors into the analysis. So I'm thinking here of the example of the CDC dealing with the five-alarm fire that was the pandemic, at least in the early days. And on the one hand, you can appreciate the agency's need to be able to speak with a unified voice to avoid public confusion. On the other hand, maybe it's especially important that the public hear from dissenting employees when the agency's own views on things are fast developing. And so I'm wondering how you think about that.
Yeah. So I think for sure, right, the courts have always recognized that a laser-focused, narrowly tailored restriction on speech can be justified if there is a weighty enough counterweight on the other side, right? So certainly, let's use law enforcement as an example, right? A law enforcement agency that had a policy on the books that said, not don't talk to the news media, but don't share with the news media confidential investigative information about unsolved cases that we are pursuing, right? That type of a laser-focused, narrowly tailored policy would survive constitutional scrutiny. So to your example of public health, right, certainly somebody could expose themselves in an individual case to disciplinary action if they just went wildly off message and started to undermine the agency's well-founded scientific viewpoint by sort of like promulgating junk science, right? If somebody decided that they were going to, and again, with the mantle of the public employee, right? Not on the weekend on a Saturday. If they want to go to an anti-vax rally on the weekend on a Saturday, more power to them. But using their identity or their mantle as a public employee, if they went wildly off script in a way that risked undermining the effectiveness of the agency's messaging, then sure, in an individual case that might be subject to discipline, but none of the policies that I've studied here are in any way laser focused or narrowly tailored. They are very blunt instruments, so that, if a school district has one of these gag policies on the books, that means that the bus driver can't go to a public rally and say, well, I'm employed as a school bus driver, but I disagree with the district's book banning policy, even though no one in the audience thinks that the bus driver is an official spokesperson for the school district or is authorized to speak on their behalf or is sharing any kind of inside knowledge gained through his bus driving expertise, right? So they're all blunt instruments. They're all overbroad. I mean, one of the important things in First Amendment law, right, is that when the government has a weighty enough justification, almost any restriction can be justified, right? If public safety or national security are at risk, then you can restrain speech. But invariably, when you ask what is the rationale for one of these don't talk to the media policies, very quickly you get to protecting the image and reputation of the agency, which again I think is entitled to zero and perhaps negative weight in the constitutional discourse. I mean, the last point I would make there is, when you restrain, and the Supreme Court has talked about, if you read the case of Lane v. Franks, which was the Supreme Court's most recent public employment First Amendment case, Justice Sotomayor there writes eloquently about the value of the expertise of public employees to participating in the debate and why we don't categorically silence them from speaking. And my answer, I guess, to the person who says, well, we need these policies to make sure that we're promulgating consistent messaging and avoid the promulgation of junk ideas is, have you been on social media lately? The only people who are being silenced are the knowledgeable people. The only people who are being silenced are the people who have expertise and information. The ignorant people are perfectly free to occupy the debate and are completely unrestrained from doing so. So I think, to take Justice Sotomayor's point, right, if we want to have a rich and well-informed discourse, that has to invite in the people who are the most knowledgeable and expert. And again, as an advocate for journalists, right, I hear all the time from journalists, I can't talk to that school librarian, that teacher, that firefighter, that emergency room doctor, because I'm foisted off on a public relations person who emails me over some pre-prepared quotes. And there's a real cost to the public understanding, what was it like to be on the front lines of COVID, to be in that ER? It's a real cost to the public's understanding of the way government works when we filter and funnel it all through a centralized public relations intermediary.
So Daniel, I'm wondering if you could sort of speak to this. Is there a point at which agonism starts to undermine effective governance? In your piece, you note that agonism might have less purchase in certain technical areas, like the management of systemic risk in financial markets or the protection of national security. And I'm wondering why that's the case and what the inclusion of national security on that list says. Because on one view, it's especially important that we hear from public employees on that topic, not only because they're the most likely to have relevant expertise, but also because there are extremely few other sources of what they know, given the heavy cloak of secrecy.
Yeah, so I think those are tough questions for the agonistic framework. I mean, when you get to the level of operational detail, you're always going to have, debatable points about this. But I guess one reason why I carved out national security and other things is because what really drives my interest in this is not so much the First Amendment, free speech, but democracy. And the relationship between the public and very multifarious public and its government, right? Trust in government, ultimately. And I think at the end of the day, looking at things from a 30,000-foot point of view, most people they already have fairly high levels of trust in national security decisions, in certain technical decisions that the government is making. There's actually really good evidence on this. Brian Feinstein has a piece, looking at experimental surveys of people who really demonstrate in those surveys that they have a high degree of trust and expertise in government. So when it comes to these kinds of decisions where there is already a pretty high level of residual trust among the public, the democracy problems or the concerns or anxieties that really drove my project are a little bit less acute. Where we need a little bit more work to show the public that the government is trustworthy, in part through contestation on an agonistic level, is precisely in kind of the area that you just brought up in your last question, things like the pandemic, which was a disaster for public trust, right? And part of the disaster of public trust was actually that there was an attempt to have very narrow messaging from the CDC in a way that didn't really respond to a lot of anxieties that certain segments of the public had. I'm not saying those were right anxieties to have about things like vaccination or masking protocol, but the reality is maybe a little bit more dissent on issues like that, where the science was rapidly developing, could have actually maintained some connection with the citizens who were prone to doubt the government, right? And we lost those people, unfortunately, very early in the pandemic by having this idea that we needed, kind of just one voice coming from CDC. So I think that in areas like that, that's where you need the most contestation. That's not a great answer from like a free speech or First Amendment perspective. There's an equally valid case to be had that we might need contestation for free speech purposes in national security, in technical areas. Again, I think I'm driven more by the democracy interests here than kind of the civil liberties or rights side of things.
So Kate and Teague, I want to bring you in here. We've been very focused on the individual right of dissent, but of course many public employees want to combine their voices, often through the vehicle of unions. And yet the courts have been fairly miserly on this front. And so Kate, you critique the court's failure to recognize a First Amendment right of public workers to bargain and strike, writing, quote, as the court itself recognize public sector union speech is inherently political, yet the current doctrine gets things backwards. Collective speech and protest by public sector workers deserves just as much First Amendment protection as speech by dissenters, if not more. Unpack that for us.
Great. Well, thank you so much for having me for this great conference, and thanks to Sam and Katie for their work to put this together. So yes, so the core problem from which I start here is that the Supreme Court has held that public sector workers have a First Amendment right not to pay union dues, yet according to the court, they have no right to engage in collective speech, collective bargaining, or to strike. In fact, it's a crime for employees of the federal government and of many states to participate in a strike, or even to join an organization that asserts the right to strike against the government. And in some states, public sector workers are also flatly prohibited from engaging in collective bargaining. Federal government and states can discipline and fire workers who seek to bargain collectively about their wages and working conditions. They can also bar employees permanently from public employment if they engage in bargaining or strikes. And according to the doctrine, none of that is unconstitutional. My argument is that this interpretation of the Constitution is at odds with the First Amendment's text and purpose and intention, even with the court's own doctrine. So the First Amendment protects the freedom of speech, and that's the focus of most First Amendment litigation, but it also protects the right of people peaceably to assemble, the right to petition the government for a redress of grievances, and the court has found a corresponding right to associate with others, including in pursuit of political, social, and economic ends. And the primary purpose of the First Amendment, the court has held, and most scholars also agree, is to advance democratic self-governance. Collective bargaining and strikes among public sector workers fall squarely within this ambit. By its very nature, public sector union activity involves collective expression, it involves assembly, it involves association, and it involves petitioning the government for redress of grievances. By seeking to improve their wages and benefits and working conditions, to improve the provision of social services, or to address other community or workplace issues, public sector workers are necessarily engaging in the kinds of political speech and democratic activity that implicates the First Amendment. And the ability more broadly of workers to form unions and to engage in concerted action in support of their shared goals is an important part of democratic governance. Through unions, workers engage in active citizenship. They express their views collectively, and they engage the government on issues of public concern, and they inform public debate about important workplace and public policy issues. In a famous case from 1940, Justice Murphy recognized that Alabama could not criminalize picketing by private sector workers because the discussion about labor disputes is indispensable to the effective, intelligent use of the processes of popular government. Ironically, in the context of the union dues or the agency fees cases like Janus, the court has recognized that public sector collective bargaining in particular is closely intertwined with politics and government, that collective bargaining implicates political issues when it happens in the public sector. And on this basis, the court has said that individual dissenting workers have a First Amendment right not to pay union fees, even when they get the benefit of a union contract and union representation. Because the speech is political, so it deserves special protection. But yet, with almost no analysis, the court has dismissed arguments for First Amendment protection for majoritarian efforts among public sector workers for collective democratic exercise of expression. And that, as Ramya said, just gets it backwards, I think. The other point I wanted to raise just by way of introduction is that public sector workers themselves have long rejected the court's parsimonious approach to their rights. And their experience, their lived experience and their efforts highlights just how central their union activity is to the First Amendment's goals. So for example, as early as the 1800s, federal government workers engaged in collective speech, assembly, and petition by striking and lobbying the government to address their grievances. One early example occurred in the 1830s when federal workers in naval shipyards struck, arguing for a 10-hour day. And President Andrew Jackson intervened and granted the demand. More often than not, however, in the 19th century and early 20th century, public sector workers were unsuccessful in their collective efforts, but even those unsuccessful efforts really highlight the First Amendment stakes of collective action among public sector workers. So, for example, in the late 1800s, postal workers sought to petition the government for better wages and working conditions. In response, the Postmaster General issued an order prohibiting any postal worker from even visiting Washington to lobby. And postal workers continued their organizing. When they continued their organizing, the Postal Service banned union membership, and President Teddy Roosevelt imposed a gag order limiting federal workers from advocating for unionization. We will hear more about this today in a fascinating paper by Sarah Mylove. After years of, but what happened was after years of organizing, Congress eventually passed the Lloyd-La Follette Act of 1912 that provided some protections for collective action and for lobbying. But it wasn't until the 1960s and 70s, after strikes by tens of thousands of public sector workers, that both the states and the federal government came to recognize the right of public sector workers to bargain statutorily. In a few states also protected the right to strike. And throughout this period, public sector workers defined their activity as First Amendment activity, as exercising fundamental rights to engage in expression and to engage in the process of democracy. Nonetheless, the constitutional doctrine endured, and their bargaining and strikes received no constitutional protection. However, and I'll end on this more optimistic note, since 2018, substantial numbers of public sector workers have begun once again engaging in pickets, protests, and strikes, even in states in which doing so is illegal. So hundreds of thousands of teachers have engaged in strikes in West Virginia, Kentucky, Arizona, North Carolina, Oklahoma, all states where there is no right to strike. And they've also done so in blue states with more labor rights, like California and Illinois and elsewhere. The rise of public sector union activity is not limited to teachers, nurses, healthcare workers, university workers, public university workers, municipal workers, and others have also gone on strike in recent years. And I think we should see this activity as an act of free speech, lawmaking, First Amendment lawmaking from below. These are workers who are asserting their collective rights and essentially exercising their First Amendment rights and engaging in a form of constitutional lawmaking from the bottom up. I think it's highly unlikely that the Supreme Court, this Supreme Court would recognize any kind of constitutional right for public sector workers to bargain and strike, notwithstanding the basis in the doctrine, but there is a lot of promise in the actual efforts of public sector workers to try to change our understanding of constitutional rights and constitutional meaning through their own efforts.
Thanks for ending on that more hopeful note of bottom-up lawmaking. Teague, your union is the largest trade union of public employees in the nation. In testimony you've given to Congress, you've said that, quote, for public sector workers, it is not just a job, it's a calling. Union members working in the public services use their collective voice to advocate for better and more efficient public services. And I'm wondering if you could tell us more about that, especially amid this recent resurgence in public sector union activity. And I'm also interested in knowing, do your members understand themselves to be advocating for the public good when they do this? Do they see themselves as engaging in democratic politics or making demands for sort of better and improvements in their working conditions like their private counterparts?
Yeah, I'd be happy to address that. It's a lot there. Hi, everybody. I'm Teague Paterson, General Counsel of AFL-CIO. We are one of the largest public sector unions in the country, and we are also one of the largest unions in the country. Today, half of the union members in this country are public sector workers. So when we talk about the labor movement, we're talking about public employees equally as much as private employees. I guess our name says it all, the American Federation of State, County, Municipal Employees. It's a little abstract. And our union is incredibly diverse in what our members do and the services they perform. We represent school bus drivers, and we represent public defenders and assistant DAs. As strange as that sounds, yes, they can form unions in some states. Doctors and dentists, corrections officers, environmental scientists, foresters, behavioral health and addiction recovery workers, just to name a few. We even represent lifeguards, and we represent the puppeteers who work at in Central Park who put on performances for kids. So it's really a very varied group of public service representatives, and that's why public service workers, that's why our motto is "We make America happen." Might sound trite, happens to be true in our view. So when our members do care deeply about the work that they do and the communities that they serve, and they do look at it that way. I mean, the public service is a calling. It really is a calling. It can be a difficult job and a demanding job, and our members are very engaged in their communities, not just on the job, but in their school districts. At city council meetings, state houses, online, so much online, maybe too much online, but they're online, and we, and it's really a fundamental part of who they are and their identity, and they care deeply about the services that they provide. I want to read. I think this is going to reflect a little bit of what Kay was saying, but I want to read from the preamble of our Constitution. AFL-CIO is governed by a Constitution. We have a Constitution Convention where all our members elect delegates every 2 years, and it's a Constitutional Convention. And so the preamble to our Constitution says that workers organize labor unions primarily to secure better wages and better working conditions. We hold that they also organize in order to participate in the decisions which affect them at work. One of the fundamental tenets of democratic government is the consent of the governed. Unions are an extension of that idea. Union members are both workers and citizens. Collective bargaining is the expression of citizenship in employment, and participation in the political life of the nation is another aspect of that citizenship. I'm gonna skip a little bit here. For unions, the workplace and the polling place are inseparable, and the exercise of the awesome rights and responsibilities of citizenship is equally required in both. And that's really, I think, our creed in terms of how our members are active both politically on the job and in their communities. I don't know if that fully answered the question, but.
No, that's enormously helpful. I'm just noticing that this. Kate, I want to ask you about the relationship between public and private workers. So, you trace this really interesting history and note that really, like up until the 1930s, public and private sector unions alike faced almost a wall of hostility from legislatures and the courts. But then you get the Norris-LaGuardia Act, you get the National Labor Relations Act, which give private workers substantially more rights, including the right to strike. And so I'm wondering what you make of this divergence in why it happened, and if there are any reasons to think that you might actually want to treat public employees as different.
Yeah, great. So, great question. I'll just say a couple more words about kind of the wall of hostility that workers faced before the 1930s. The court, during the Lochner era, as everyone knows, repeatedly struck down statutes that aim to protect workers both in their collective rights and also minimum wage laws, overtime laws, under the liberty of contract theory, and also repeatedly held that Congress lacked power under the Commerce Clause and so on to enact such statutes, and use various conspiracy doctrines and antitrust laws to enjoin worker strikes. And so it was not at all uncommon for labor leaders in the private sector as well to be arrested and sent to jail, and for troops to be used against strikes. That changed in the 1930s with the passage, as you say, of the National Labor Relations Act and the Norris-LaGuardia Act, but those statutes only applied to private sector workers. So by statute, private sector workers do have the right to bargain and strike, although it's limited in some ways. And I think in many ways, the interests of public sector workers and private sector workers and the speech interests and the expressive and democratic interests that are at stake are quite similar. So in many cases, private sector and public sector workers do the same kinds of work, as we heard from what Teague was saying. Healthcare work is done in both sectors. Education is done in both sectors. The federal government has contracted out a tremendous amount of work that was once public and is now private. And both kinds of organizations are critical. Both public sector organizations of workers and private sector organizations of workers are critical components of democracy, they enable workers to serve as a countervailing force to big business money in politics. They enable workers to have a voice in the democracy. So in all of those ways, and I should also say, if you look at kind of comparative research and historical research, both private sector unions and public sector unions have been very important in staving off authoritarianism. So in all of those ways, they're quite similar. But there are also real differences. In some sense, I think the First Amendment is more implicated in the context of public sector workers, for both because there's automatically state action because the government is involved, but also because, as Justice Alito recognizes in his opinion in Janus, the public sector workers, when they are bargaining about their working conditions, about their salaries, are bargaining about government policy, are bargaining about democratic policy issues. So in that sense, the First Amendment is more implicated, and even more, we could imagine a doctrine that provides more protection. On the other hand, whenever there's a First Amendment right, the government also has interests. And sometimes with public sector workers, there's a greater interest on the part of government to limit strikes. So you can imagine, for example, firefighters, right? The risk of strikes by firefighters might be much greater than the risk of strikes by GM workers. And so, but none of that enters into the court's analysis now, because there's not even the recognition of the importance of the right in the first place. But certainly there are certain kinds of public sector workers who provide essential services where in any kind of balancing or proportionality review, or where you would imagine, I would imagine, less protection for some of their collective action due to the nature of their work. National security would be another obvious example.
Could I have 30 seconds to follow up on that? Staying on message, so my message being that workers should be free to share their expertise with the news media. There's actually a very well-established strain of NLRB precedent going back decades that says that even in the private sector, in an NLRB-governed workplace, which is every major corporation in America, that these media gag rules that say no one here can talk to the press or the public about their work without permission are unlawful even in the private sector where the First Amendment doesn't apply, because that is an unfair labor practice, a narrowly tailored policy in the workplace that says, don't share our trade secrets, don't share our confidential customer data is permissible, but a blanket restraint on speaking to the press or public about anything work-related has always been held to be unlawful whenever it is challenged. The problem is, again, the huge disconnect between the law and the practice on the ground is that the NLRB has a very tiny hammer, and the only pain that they are able to inflict upon you is to say, please change the policy, which is just the cost of doing business, right? It's a minor inconvenience to change my policy, but if they were able to inflict pain upon workplaces, then I think those policies would be readily changed. But it's important to know that those are out there, even though it's completely inconsistent with the practice on the ground.
That's really interesting. Teague, I'm wondering what arguments, your union, your members usually hear from management against public sector strikes and how you've responded to them. Do they make this argument, about the importance of sort of the public sector presenting a united front, speaking with one voice, invoking sort of like arguments about public confidence, or what sorts of arguments do you encounter?
Well, our emphasis, we are not so focused on strike activity. Yes, it happens. In the public sector, it's extremely curtailed. There's some states where it's permitted in certain circumstances. California, Illinois come to mind. But, I think that if you look at we heard about some of the strikes from Kate. Does anyone, by the way, know the first recorded labor activity, when that happened? Anybody? So in the 12th century, before the Common Era, there's an archaeologist found a papyrus scroll that dated to the time of Ramses III. So we're talking 4,000 years ago. And on that scroll, it recounted a story of stonemasons, artisans who weren't getting their rations. They didn't have currency, so rations were what you got paid in, essentially. These were skilled workers. And so they did what workers have done throughout history since. They downed tools and they marched on the boss, and they went to the pharaoh's representative and said, we're not working until we get our rations. And I guess they were having supply chain issues. And it got sorted out, and they had to strike a few times. And so I'm especially proud that the first recorded labor action in human history was public employees, right? Workers for the sovereign. And so, there is a fundamental difference between collective bargaining with the sovereign, whether it's the governor or a federal agency head, or city council or mayor, than with a private business. And obviously the rules are different. When I say that our emphasis isn't on strikes per se, it's because if you look at the history of public sector unionism in the United States, the striking is really more of a matter of obtaining recognition and obtaining the right to collective bargaining. So if you think about the city of New York, in 1968, the social service and welfare workers struck. Some of them went to jail, there were fines, but ultimately the result of that was the passage of New York City's labor law. New York City has a different labor law than it's applicable to the rest of the state. And since then, yes, there's been a few strikes here and there, but I don't know if anyone here can think of major strike activity in the last 40 years. I mean, it happens, but again, it's not like it was in the 60s and 70s. And I say all that because when you have a system that reasonably channels disputes into a mediation, and most, I don't want to get too into details, but most public sector labor relations statutes, when you reach an impasse in bargaining, the end isn't economic action like it is in the private sector. There's a whole series of things that have to happen, and usually do happen, even in places where the right to strike exists, like in California or Illinois, for example. And so if you look at the private sector, where there is a right to strike, again, severely limited, right? It's been defanged by the Supreme Court and the NLRB. What's union density in the private sector? 6%, okay. In the public sector, where for the most part you don't have the right to strike, what's the union density? 30%. And that's average, okay? In New York State, it's, you know, majority percentage of people are in unions, all without the right to strike. So when I say it's not so much our focus, it's because we think there are more productive ways to resolve labor disputes, and often that includes working with the many stakeholders that you have when you're representing public sector workers. So, you know, the stakeholders are the community. They are the pupils and the parents who are affected by a teacher strike, right? The taxpayers. And frankly, there's a political valence that doesn't exist in the private sector, that in some ways is more effective than economic action.
I've got a couple of questions that have come through the Q&A. First is a question for Kate. Is there more favorable free speech doctrine on labor rights in state courts interpreting state constitutions? And if not yet, are there state Supreme Courts and constitutions where there might be a good opportunity to establish those rights?
Yeah, great question. So when it comes to private sector workers, state courts and state legislatures are severely constrained by federal preemption doctrine. So states can't pass laws that improve the rights of private sector workers to organize, and state courts, they could say there's a free speech right of private sector workers to organize, bargain, but it would be preempted by federal law. When it comes to public sector workers, however, states have a lot of ability to both legislate and make constitutional law. And there's a lot of variety among the states. So, you know, Teague was just talking about the high rate of union density among public sector workers. That's really limited to certain states. And there's absolutely zero density, zero right to have a collective bargaining in many other states. There are some, but because there are strong statutes in places like California, Illinois, New York, we haven't seen that much in the way of constitutional law development. However, there are a couple of interesting recent developments. One is that Illinois recently amended its constitution to affirm the right of workers to engage in organizing, bargaining, and strike. So that it's for purposes of private sector workers, that's just expressive because the NLRA preempts any improvements. But for purposes of public sector workers, it kind of locks in the Constitution the rights of workers, which are already protected in statute in Illinois. Another example from New York applies to farm workers. So they're not public sector workers, but they're not covered by the NLRA, and they sued. Some groups of farm workers sued, and the New York courts held that there's a constitutional right of all workers in New York to have union rights, and that led to a new statute, and so there's new organizing occurring there. So there's some constitutional development, but it's fairly constrained because of strong federal preemption principles, and also because in states where you have more progressive courts, there's already strong statutes.
If I could pile on a little bit, I mean, there's a number of states that do have these constitutional provisions that guarantee the right to collective bargaining. I think probably about half a dozen. Many, not all of them, but many of them date to the period of time when it was unclear whether the Supreme Court would find the Wagner Act constitutional or not. So a lot of states passed these laws in the chance that the Wagner Act would be overturned by the Supreme Court. Just a little interesting history. Fast forward, and with NLRA preemption, in those states, all of those states have found that, and this was a result of subsequent litigation where the states did not automatically apply that right to the public sector. In each of those states, as a result of lawsuits, unions were able to establish that those provisions extended to the public sector. So it's a little bit of unintended consequences.
So another question about the topic of workers' rights. To what extent are workers' rights or their ability to exercise them dependent on public support and sympathy for their cause? Is there any evidence that courts weigh this support in their decision making?
So I think the success of public sector workers' efforts in bargaining and strikes is very dependent on public support, and I think public sector unions are aware of that, and so they often shape their demands with the public interest in mind. And also, as we were hearing from Teague, the work that public sector workers do is work for the public, and so they are already thinking about the public's interests. And one example of that recently is the Chicago teacher strikes and the LA teacher strikes, and then bargaining here and elsewhere where there weren't strikes of teachers really prioritizing education goals and smaller class sizes and more funding for schools, and even in Chicago, funding for social work and housing for children who lack it. And so I think that's in part because that's what workers themselves actually believe in, and in part because they also recognize that in order to succeed, they need public support. I do think the courts take that into account in the sense that we haven't seen, of course, and also prosecutors, attorneys generals, we haven't seen successful prosecutions or criminal penalties or injunctions brought against some of the recent teacher strikes because they've had so much public support. I think the picture would be different if they didn't.
Okay, sure.
My question is related to the point that elections have consequences.
Okay.
So when you have a governor, for example, who comes in, he doesn't like the policy of the administration prior to this coming in. He's coming in with people who put him in. So, for example, in New Jersey, you had the New Jersey Department of Higher Education and New Jersey Lower Education, Commissioner of Lower Education and Chancellor of Higher Education. The governor disagreed with their public policy. He disagreed with the Board of Education, and he disagreed with the Board of Higher Education. And he wanted change, and he told the staff of both departments, do not talk to the press. The only people who talk to the press is my office, my menus. And then the Chancellor of Higher Education couldn't talk to the press. The Commissioner of Education couldn't talk to the press. The Board of Education could not talk to the press. The Board of Higher Education could not talk to the press. So my question to you is, do not elections have consequences?
I mean, they clearly do have consequences, but it's partially because we allow this simple accountability logic and simple models of democracy to prevail. I mean, this is not just at the state level, as you mentioned, it's also at the federal level. I mean, you don't need to dig very far into the U.S. reports to see the Supreme Court, invoking this kind of accountability logic in the context of, say, the unitary executive theory, and in attacks on civil service, removal protections, for instance. So, it's all over the place. This model that, I am the decider. I was elected by a national population, national electorate, and everything should bend to my will. And that's obviously pregnant with a lot of danger, authoritarian danger. But we don't need to throw out democracy in order to resist that. We just need a slightly more expansive understanding of what democracy is, one that actually accords more with what political theorists, people who think a lot about this, are thinking about. So that was what I was trying to say with the agonistic democratic theory perspective, one that values contestation and dissent. It's a complication of these traditional simple models of democracy that try to reduce everything to a single demos controlling government decision making via elections. Now, whether people are open to that more complicated model where there is actually dissent and kind of two-way communication between civil servants and executives who are elected, I don't know if people are open to that, but we ought to be having that conversation because elections matter has a lot of power intuitively, but you peer below the surfaces, it's a lot more complicated than that.
I would add too, I think it's a really good question and it's a good example, I think that there is a distinction, and it's reflected in the law, that the people who drive policy, the sort of people that are being brought in by the new elected official, their sort of right of dissent may be quite a bit different than rank and filers. So, a teacher who says, well, this new lunch policy is going to be bad for my kids is a lot different than, the head of the Department of Education saying, the governor is hurting, the students, that kind of thing.
Just for the people who were listening online who maybe couldn't pick up everything that was asked, I won't be able to replicate the eloquence and the passion of the question, but I will do it in a very generic way. The question was, well, what if the governor or a mayor indicates that nobody but myself or my chosen appointees may talk to the news media? And the answer is, under prevailing First Amendment case law, both from the Supreme Court and right here in the Second Circuit, that would be an unconstitutional prior restraint that would readily be struck down if it were challenged. Two comments on that. First of all, it is quite hard to tee up one of these cases, because rarely is a public employee so motivated to speak to the press that they are willing to be adverse to their own employer in a federal lawsuit, right? So invariably, the only person who brings that legal challenge is someone who has already been fired and therefore has nothing to lose, right? Which is one reason why these policies are so sticky and so persistent and so hard to get off the books, because it's very hard to find a motivated challenger. My second point is, your question exposes why these policies are so obnoxious and why they should be challenged, because invariably, even if the policy on its face seems to be viewpoint neutral, it will always be enforced in a viewpoint discriminatory way. The only people who will be punished are people who are regarded as critics or dissenters, right? And so a policy that on its face is neutral but is enforced in a viewpoint discriminatory way also is an unconstitutional policy.
Just really quick response to what Frank just said. I agree, if you read the case law, it probably is the case that a prior restraint of that sort, blanket order to civil servants to kind of keep hush, is probably constitutionally problematic. I'm not confident, though, that the courts are going to continue to follow that line. Especially if you look at the federal courts, and especially this U.S. Supreme Court, courts like the Fifth Circuit, they are, I think, moving forward with an understanding of executive power that is, a very managerial one, and how the First Amendment case law interacts with that commitment to managerial government, unitary executive theory, I think is an open question. And on the margins, I could see courts not really sticking to what they've said in prior cases on, say, First Amendment doctrine. So I think we need to think about the interaction of those two threads here, and then also have a little bit of skepticism about courts as likely defenders of the values we're talking about. We need to talk about other ways of instituting methods of dissent and contestation as a means of promoting democratic legitimacy that are more bottom-up and not court-centric.
Am I allowed to take questions in the room? Okay, is there a microphone that can be handed?
Why don't you borrow mine?
Okay.
So I'm really intrigued by this idea that contestation is going to increase the trustworthiness of government. And I have one line of thought that sort of compares contestation and transparency and how they're similar and different. That's not what I want to ask. What I want to ask is about the potential difference of contestation of policies and contestation of facts. Because I think a lot of, like the example you gave with the pandemic, a lot of that was about contestation of actual facts. Same thing in a lot of disputes about whether there's election fraud or not. And so I wonder if you have to cabin your claim to contestation of policies rather than contestation of facts, especially given all the social science that once disinformation takes hold, it is really, really hard to get people to shake it. And I say that knowing it's not always easy to distinguish between policy and facts, but that was the question that I had.
Yeah, so it's a great question. I agree with the intuition that kind of the most ripe space for contestation is over discretionary policies, right? Where somebody comes in on an electoral mandate and tries to implement a policy, but that's a matter of discretion. They could have gone in other directions. Maybe there are other, values that are being ignored by the newly elected managers. So that's the most logical space in which to build in sites for contestation and dissent. But I would resist the idea that it would be entirely irrelevant for facts as well. I think you're right to be worried about the danger of misinformation getting out. But especially, when new issues are arising and the facts are developing, I think there is value in allowing there to be dissent even over facts, with the expectation that the public will receive that and hopefully process it in a positive way. Hopefully hear countervailing voices that say, really, the facts are becoming clear on the ground, and be persuaded by that. Now, I'm not naive enough to think that everybody will not go off the deep end if they hear counter speech on factual issues that are quickly becoming crystallized as true facts. But I think it's a little bit hard to draw the line, as you point out, between policies and facts. I would just go back to what I said originally, though. I think, especially when it comes to policies, this is something that we can and should do, and it would probably increase public trust, just to see that the government doesn't speak with one single voice and isn't leaving everybody out, or certain segments of the population out when it makes those decisions.
Just to amplify on that, as a matter of First Amendment doctrine, right, what the courts have always told us is that the preferred remedy under the First Amendment, under the marketplace theory, is counter speech, right? And so it would rarely be the case that any individual, let's just use your example of a public health agency, any individual person who works for a public health agency would have a megaphone larger than the CDC or larger than the New York City Department of Public Health. And so I think unless it is proven that the counter speech remedy will be ineffective, then the First Amendment will always favor that over silencing the dissenter.
But part of my concern is counter speech has been proven to be ineffective.
That's the question.
Are there other questions in the room? Okay, well, I have one of my own then. Okay. So recently you had a group of federal employees face pushback after organizing a walkout over the Biden administration's policies regarding the Israel-Gaza conflict. Although the group encouraged members to take leave, top Republican lawmakers called for the participants' removal. This statement from the chairs of the House Oversight Accountability Committee is pretty representative of the stuff that these lawmakers were saying. Quote, federal employees are accountable to elected leaders and the American people. They are not an unelected fourth branch of government that gets to pick and choose which policies are right for the country. I think I've already heard, sort of some people's response to this argument, but I wonder, does it matter, for example, which agencies these employees worked for example? Do they work for state or defense? And Daniel, because you mentioned the dissent cables before, I wonder if you think the fact that the agency gives employees an internal mechanism for expressing dissent, whether that weighs at all, and whether they should be able to express this dissent publicly as well. And does it also matter what the employees' sort of positions at the agencies are? Anyone?
Yeah.
Go.
I think I've made my perspective on these questions pretty clear. It is a little bit different for civil servants in the State Department to express their views internally and to have those avenues via the dissent channel versus speaking to the public. But again, I actually think if you're coming at this from a perspective of trying to increase trust in government and enhance the legitimacy of democracy, it's especially in those public communications that you want people to be able to voice the minority positions, push back against managers. So I don't see a lot of difference between, the kind of policy or democratic question of whether you allow those internal dissent mechanisms versus public ones as well. So yeah.
I think that it's a public protest over a matter of public interest. To the extent that there are internal means of raising those concerns that these workers were concerned about, they clearly weren't adequate, or they clearly didn't feel like they were going to result in their voices being heard. The fact that they were taking leave time. I mean, to me, this sounds like it's no, public employers and private employers want the same thing, right? They want loyalty, undivided loyalty, and absolute control, okay? And there's no difference between the public and private sector in that sense. There are laws in the public sector that exist, civil service laws, merit system laws, so that public employees have more space and more protections to engage in those kinds of actions that the boss might deem to be disloyal. So that's sort of my viewpoint. I think perhaps if these people were walking out over a different policy, it may not have been quite as controversial, right? And so but that's neither here nor there when you're talking about First Amendment considerations.
Just as a matter of First Amendment doctrine, right, the First Amendment actually treats internal versus external workplace speech quite differently. The Garcetti principle, which is the leading First Amendment case from the Supreme Court on workplace speech, right, says that when you do nothing more than just report up the internal chain of command, then your First Amendment rights are at their lowest. Whereas when you speak in a way that is calculated to engage the larger public, then your First Amendment rights are at their highest. And so the existence of an internal whistleblowing mechanism does not, in the land of First Amendment doctrine, substitute for the ability to go public. Those two things are treated categorically differently.
One thing I should have said, and I'll add now, is just that, I think civil servants are quite judicious about how they use some of these extra legal remedies. We notwithstanding some of the rhetoric that gets bandied about, civil servants are not acting as if they are a fourth branch of government. They don't actually view themselves that way. What they view themselves as is a highly professionalized body of workers who have unique knowledge and expertise and a lot of experience working on issues with a valid viewpoint that needs to be expressed. And it's only on occasion that they really pull out the heavy artillery and do things like a walkout. Even with things like strikes in labor relations, that is an extraordinary remedy. We've seen it recently with teacher strikes where they've gone out and done strikes even when it wasn't legally permissible, but they're not doing this on a regular basis, right? So I think we have to be a little bit worried about kind of the rhetoric that's out there that the fourth branch is trying to take over the operations, that they have any capability of doing that. In reality, civil servants are a much more reserved group, and they actually probably need to be encouraged a little bit to dissent and contest policies and get out of their comfort zone a little bit.
I want to be a little provocative. Sure. I want to be a little bit provocative. Donald Trump has transition plans that the media reports include reclassifying tens of thousands of civil service positions into directly politically accountable positions, especially with respect to the DOJ. If we think about democracy, Dan's using it, is Donald Trump's view of and you say the deep state is the Donald Trump view, but wouldn't reclassifying and returning to the Chester Arthur administration or the Grant administration approach more dramatically and directly infuse democratic politics and democratic ideas into the administrative state? It seems to me the argument many of you are making, and I agree with it for what it's worth, is that we want a deep state. We want expertise. We want Brussels. We want bureaucrats who are making fact-based, well-informed policies. and not simply taking folk tales or urban myths and writing them into, say, COVID response. But in some ways, if what we want is democratic controls, does Donald Trump and his transition plan better afford or better accommodate democratic input into the administrative state? Or should we actually be with Team Brussels and sort of say, well, there have to be limits on democratic controls to ensure that policies are actually fact-based and efficacious?
So I think you're referring to the Schedule F executive order, which Trump is talking about on the campaign trail reviving. I mean, I would not concede the point that democratic accountability is solely from elections and political mandates to come in and install political appointees in the bureaucracy. Again, as I've said, democracy is about much more than that if you adopt a more agonistic perspective. Now, one thing I will say about Schedule F, and this is maybe going to sound counterintuitive, but I'm kind of happy that President Trump is pushing Schedule F and talking about it, because it actually inspires a lot of the contestation, countervailing power on the other side that I expect will probably happen if he actually attempts Schedule F. I mean, that would be a major incursion on the traditional domain of civil servants, people who are protected from political interference. And, I fully expect that if he does it, there will be resistance, whether it's, covert or overt, I don't know. But I think it's good that we would have that kind of fight about what our government stands for. So I don't begrudge Donald Trump for, proposing the idea of Schedule F and to leaning into a particular notion of democratic accountability, that everything stems from electoral mandates. That is one version of democracy, but I think it will actually be good if we get more articulations of democracy, more bottom-up democracy in response to that. And it'll problematize these issues in a helpful way that I think will be, on balance, even more democracy than we could expect if Schedule F was just accepted.
Does everyone know what they're talking about, Schedule F? It just sounds very wonky. It's also so basically, it would be a new schedule that would create a category of federal employees that would not be protected by the merit system. And so currently, very high-level policy-making positions, generally defined as political appointees, are not in the civil service positions, don't have civil service protection. Schedule F would create a new category of anyone who has any involvement in any policy making, and so it reaches very, very far down into the federal bureaucracy and would remove those people from having civil service protection, so they'd essentially be at-will employees. So I just want to make sure everyone knew what we were talking about.